If you have been waiting for good news in the U.S. immigration system, this may be the moment you have been hoping for. January 2026 is bringing a series of significant policy changes that could benefit hundreds of thousands of immigrants, families, students, and professionals across the country. For once, the updates are not about restrictions or new barriers. They are about expanded opportunities, faster processing, and long overdue relief for people who have been stuck in the system for years. In this video, I am going to walk you through every major win coming in January 2026, explain who qualifies, and show you exactly what these changes mean for your specific situation. But I need you to stay with me until the end, because the final update I share could be the most important one for your family. Before we discuss what is changing, let me provide some context about why these updates are happening now. The U.S. immigration system has faced extraordinary pressure over the past several years. Backlogs have grown to historic levels. Processing times have stretched far beyond published estimates. Families have been separated for years longer than necessary. Skilled workers have remained stuck in green card queues that span decades. And students have faced uncertainty about their ability to remain in the country after graduation. In response to these challenges, multiple government agencies have been working on coordinated reforms. USCIS, the Department of State, the Department of Labor, and the White House have each announced policy adjustments designed to modernize the system, reduce backlogs, and provide relief to applicants who have been waiting the longest. January 2026 represents the implementation date for many of these reforms. This is not speculation about what might happen. These are confirmed policy changes with specific effective dates, and if you understand them correctly, you can position yourself to benefit from them fully. Let me start with the first major win, and this one affects employment-based green card applicants directly. Beginning in January 2026, USCIS is implementing an expanded concurrent filing policy for certain employment-based categories. What does this mean in practical terms? Previously, many applicants had to wait until their priority date became current before filing their I-485 adjustment of status application. This created a frustrating situation where workers could have approved I-140 petitions, but still wait years or even decades before taking the next step. Under the new policy, applicants in certain employment-based categories will be able to file their I-485 applications earlier in the process, even if their priority date is not yet current. This is significant because filing your I-485 unlocks several important benefits. You become eligible to apply for employment authorization through the I-765. You can apply for advance parole travel documents through the I-131, and in many cases you gain additional flexibility in your employment situation. But this is where many applicants go wrong. Not everyone qualifies for concurrent filing under the expanded rules. The eligibility depends on your specific category, your country of chargeability, and how close your priority date is to becoming current. Filing prematurely without understanding the rules can result in rejection and wasted fees. Later in this video, I will explain how to determine whether you qualify. The second major win involves family-based immigration, and this update has been anticipated by millions of families. The Department of State has announced expanded visa appointment availability at consulates worldwide beginning in January 2026. During the pandemic years, consular operations were severely reduced. Even after reopening, many posts struggled to clear the backlog of pending interviews. Families who had approved petitions waited months or years simply to schedule an interview appointment. The new initiative increases staffing levels at high-volume consulates and extends operating hours at posts with the longest wait times. Countries like India, Mexico, the Philippines, and China will see the most significant increases in interview capacity. What does this mean for you? If you have a family member abroad with an approved I-130 petition waiting for an interview, the wait time for scheduling that interview should decrease substantially. Cases that might have waited 12 to 18 months for an appointment could potentially be scheduled within 6 to 9 months under the new capacity expansion. However, increased interview availability does not mean automatic approval. Consular officers will still evaluate each case on its merits. Documentation requirements remain the same, and any issues with the petition or the applicant's eligibility must still be resolved. The win here is reduced waiting time, not reduced scrutiny. The third major update affects international students and recent graduates, and this one addresses a problem that has caused enormous stress for years. USCIS is implementing new STEM OPT extension procedures that simplify the application process and provide additional flexibility for students in science, technology, engineering, and mathematics fields. The 24-month STEM OPT extension has been a critical pathway for students to gain work experience and transition to H-1B status. But the application process has been complicated, and processing delays have caused gaps in employment authorization. Under the new procedures, students applying for STEM OPT extensions will have access to expedited processing in certain circumstances. Additionally, the grace periods for employment gaps and employer transitions are being clarified and, in some cases, extended. This provides students with more security during the transition between their initial OPT period and the STEM extension. For students currently on OPT who will be applying for STEM extensions in 2026, these changes could mean the difference between seamless continued employment and stressful gaps in work authorization. If you are in this situation, pay close attention to the specific effective dates because applications filed after January 2026 will be processed under the new procedures. The fourth win is perhaps the most emotionally significant for many families. It involves humanitarian protections and relief from removal. Beginning in January 2026, new guidelines take effect for how immigration courts and USCIS adjudicators evaluate certain discretionary factors in cases involving long-term residents with family ties in the United States. While this does not create any new legal status, it provides clearer frameworks for how officials should weigh factors like length of residence, family relationships with U.S. citizens, community contributions, and hardship to qualifying relatives. For families living with uncertainty about potential enforcement actions, these guidelines may provide a path toward stability. Cases that might previously have been decided unfavorably could receive more balanced consideration under the new framework. I want to be very clear about this point. These are guidelines, not guarantees. Individual case outcomes depend on specific facts and circumstances. No one should interpret these changes as automatic protection or relief. But for families who have been living in fear, the updated guidelines represent a meaningful shift in how their cases may be evaluated. The fifth major win affects naturalization applicants, and this is welcome news for green card holders pursuing citizenship. USCIS has announced a naturalization backlog reduction initiative that takes full effect in January 2026. The agency is deploying additional adjudication staff specifically dedicated to N-400 citizenship applications. Processing times, which stretched beyond 12 months at many field offices, are projected to decrease significantly. Additionally, the agency is expanding options for civics and English testing to reduce interview backlogs. Certain applicants may have access to remote testing options or expanded testing center locations. These changes are designed to make the naturalization process more accessible and efficient without reducing the integrity of the examination requirements. If you are a green card holder who has been delaying your citizenship application because of concerns about long processing times, the January 2026 changes may make this an ideal time to file. Shorter processing times mean faster access to the benefits of citizenship, including the ability to vote, petition for family members without country-based quotas, and obtain the full protections of U.S. citizenship. Now, let me explain who stands to benefit most from these combined changes. Employment-based applicants from backlogged countries, particularly India and China, will see the most significant impact from the concurrent filing expansion. If you have been waiting years with an approved I-140 but unable to file your I-485, this policy change directly addresses your situation. Families with pending consular cases will benefit from expanded interview availability. If you have relatives abroad waiting for visa interviews, the new capacity increases could substantially reduce your separation time. International students in STEM fields will benefit from streamlined OPT extension procedures. If you are planning to transition from student status to employment-based status, the new procedures reduce the risk of gaps in your work authorization. Green card holders ready for naturalization will benefit from reduced processing times. If you have been eligible for citizenship but hesitant to apply, the Backlog Reduction Initiative creates favorable conditions for filing. And families with long-term residents facing uncertainty will benefit from the updated discretionary guidelines. While not a guarantee of any particular outcome, the new framework provides clearer standards for how cases should be evaluated. What happens if you ignore these changes? For employment-based applicants, failing to take advantage of concurrent filing when eligible means continued waiting without the benefits that come from a pending I-485. You remain tied to your employer without the flexibility that employment authorization documents provide. For families with consular cases, not actively monitoring appointment availability means potentially missing opportunities to schedule interviews when slots open up. Consulates with increased capacity may fill quickly as applicants respond to the expanded availability. For students, not understanding the new STEM OPT procedures could result in filing under the old rules when more favorable procedures are available, or conversely, filing too early and missing the benefits of the new system. For naturalization applicants, waiting to file means waiting longer than necessary for citizenship benefits that could be available to you. And for families relying on discretionary relief, not understanding the new guidelines means potentially failing to present cases in ways that align with the updated evaluation framework. What should you do with this information? First, identify which of these updates applies to your specific situation. Not every change affects every applicant. Focus your attention on the policies that directly impact your case. Second, verify the specific effective dates for the changes that apply to you. Some take effect on January 1st. Others have phased implementation dates throughout the month. Timing matters in immigration, and filing at the right moment can make a significant difference. Third, gather your documentation now. If you will be filing an application under new procedures in January 2026, use the remaining time to ensure your documents are complete, current, and properly organized. Do not wait until the last minute. Fourth, consult with a qualified immigration attorney if you have questions about how these changes affect your specific case. The information in this video is for general awareness. Your individual circumstances may involve complexities that require professional guidance. Fifth, monitor for updates. Policy implementation can change. Additional guidance may be issued. Staying informed through reliable sources is essential as January 2026 approaches. Let me summarize the key takeaways from this video. 1. January 2026 brings multiple significant wins for immigrants, including expanded concurrent filing, increased consular capacity, streamlined STEM OPT procedures, naturalization backlog reduction, and updated discretionary guidelines. 2. These changes benefit employment-based applicants, families with pending consular cases, international students, naturalization applicants, and families seeking discretionary relief. 3. Taking advantage of these changes requires understanding the specific rules, timing your applications correctly, and preparing your documentation in advance. 4. The window to prepare is now. Do not wait until January to understand how these policies affect you. If this information was valuable to you, subscribe to this channel for continued updates on U.S. immigration policy, processing times, and procedural changes. In my next video, I will be providing a detailed breakdown of the concurrent filing expansion, including exactly how to determine whether you qualify and what documents you will need to file. Thank you for watching. Stay informed, stay prepared, and I will see you in the next one.